Hi, my name is Roxana,
And my name is Juan Manuel A.
and today we're going to be talking about advertising intellectual property. So, what is advertising intellectual property? It relates to do with all aspects of marketing or brand design that can be protected by IP laws by acquiring a patent, a trademark, a copyright. And some examples of this include commercial identity, which includes brand names, logos, and even product names. Promotional collateral, which includes web pages and custom-made advertisements, and creative assets that include artwork, photography, literature, and we're going to be talking about more about creative assets in one of the cases that we're going to go over. And it's important to know the limitations of what can be protected under intellectual property, specifically for brand owners, in order to ensure compliant ad campaigns. This is because it can be hard to protect a marketing strategy. And so all the ideas and concepts must be fully expressed in tangible form in order to acquire a protection. Otherwise, it can't be protected under IP laws.
So some of the cases that we're going to take a look today regarding intellectual property will be the Mattel and MGA Entertainment case and the Louboutin and Yves Saint Laurent case. So first we're going to start with the Mattel and MGA Entertainment case. So some of the facts regarding this case is that Mattel Inc. and MGA Entertainment they were in a legal dispute between the two toy manufacturers. So primarily revolving around the popular Bratz doll, which were created by Carter Bryant, who was previously employed at Mattel. Mattel alleged that MGA and Bryant infringed on Mattel copyrights and violated the term of Bryant's employment agreement with Mattel by working on Brad's doll while still employed at Mattel. So some of the issues, the main issue in this case evolves around the intellectual property right and ownership of the Bratz doll. Mattel and the maker of Barbie uh, sued MGA Entertainment, the creator of Bratz doll, claiming that the Bratz doll designs were conceived by a Mattel employee, Carter Bryant, while he was under contract with Mattel. Mattel alleged that the designs were therefore its property. The case involved multiple legal claims, including copyright infringement, trade secret misappropriation, and breach of contract. The dispute raised question about the scope of invention assignment agreement and the ownership of intellectual property rights in the context of employment. So the case went through several court proceedings and appeals with various outcomes. However, one of the key rulings from the Ninth Circuit Court of Appeals in 2013 ultimately favored MGA Entertainment. And here are some of the rulings, the rules that came out of these case. So first, the ideas and concepts that are not fully developed and only exist in an employee's mind without any tangible form of expression cannot be considered as a property owned by employer, even if the ideas were conceived during the period of employment. The second one is invention assignment agreements, which assign an employee's invention to their employer must be evaluated carefully to determine if they cover the specific ideas, concepts, or inventions in question. And the third is for copyright infringement claims, the court emphasized that copyright protection only extends to work that are fixed in a tangible medium of expressions and not to general ideas or concepts. And so yeah, this ruling clarified the scopes of intellectual property rights for employers and employees, particularly in cases involving invention assignments, agreements, and copyrightable work. The case also highlighted the importance of carefully drafting employment agreements to avoid ambiguities and potential legal disputes related to intellectual property rights.
Okay, so the second case that we're going to look at is the Louboutin versus YSL case, which involves a dispute between both luxury designers, Christian Louboutin and Yves Saint Laurent, over the use of the red sole shoes. And Louboutin claimed that YSL's use of red soles infringed on their trademark that they had for the red soled shoes. So Louboutin sued YSL for trademark infringement on the red sole mark in August of 2011, where it was initially heard in the Southern District of New York. And the court denied Louboutin's request for a preliminary injunction because they questioned the validity of Louboutin's trademark, suggesting that a single color could not be trademarked. And Louboutin then appealed this decision. So the issue that the court had to decide then is a single color able to be protected by a trademark or not. And so the rule that we get from this case is that the court in this case decided that a single color can be protected as a trademark if it has acquired a secondary meaning to consumers and it is distinctive, which in this case it is, as many consumers know Louboutin specifically for their red soles, but it can be limited depending on the context. So that's where the court comes in. But in Louboutin's case, the red sole trademark is only protected when it contrasts with the color of the rest of the shoe. And so this doesn't apply to monochromatic red shoes. So YSL can continue to produce monochromatic red shoes just as long as the red sole isn't different from the rest of the shoe, because that is protected and can only be produced by Louboutin.
Yeah, so in summary, we advertising intellectual property rights can be complex and nuanced, with protection extending to specific elements like color trademarks, tangible expression of ideas, and employee inventions through well-defined agreements. Understanding these limitations is essential for advertisers, business owners, and creators to ensure that their intellectual property is protected and disputes are minimized. Thank you so much.
Thank you. These are our references.